punishment in a way is for life. But if I were to go murder somebody, if I would commit treason, if I were to kidnapping, I could come back and contest election.
Where from the tribunal gets the powers for life time disqualification?
It has declared.
No, where from gets the powers to declare him
Has
for
declared
life?
a decree given remains intact for all purposes.
Fair enough, we've understood that.
Next point.
Now this argument basically it lies in Islamic principles. If you look at PPC, out of all those offences, there are very few offences in which mens rea is dishonesty. My submission is, wherever mens rea is dishonesty, we are talking about public office holder.
जो आपने you just very casually referred to Islam, either back it up because I completely disagree with you. You have to back it up. If your contention is agreed, there were those who were violently opposed to Islam, and then they became Khalifs, Khulfa Rashideen. तो वो आ ही नहीं सकते थे फिर वापस. This just don't throw in Islam just like that. It is contrary to Islamic injunctions. तौबा का प्रिंसिपल है, राय रास्त पे प्रिंसिपल वापस आने का प्रिंसिपल है, मुस्तकीम शारे मुस्तकीम पे वापस आने का प्रिंसिपल है. All शुरू में तो 2-4 ही मुसलमान थे.
I mean, we are.
तो ये आप ऐसे just don't throw in Islam to give it a validity.
No, my lord. What I am submitting is, if repentance or tawbah, when we look at it,
repentance और तौबा की तो बात से आगे मैं चला गया हूँ.
that's what I am submitting. These are 3 things kept by God to Himself. Number 1,
Not at all.
Izzat Zillat.
Not at all.
Let me make my submission.
No submission. You refer to the Holy Quran. You can't just make a submission contrary to Islamic principles like this. ऐसे नहीं होगा.
Could I change the subject a little? Let me just introduce one other aspect. Let's stay on 62(1)(f). If we look at 62, some of the disqualifications or qualifications are mentioned in the Constitution itself, like he has to be a citizen, the age and all. This is specifically provided. 62(1)(f) brings in a disqualification from a declaration from another court under some law, not the Constitution. It is a declaration of disqualification under declaration of contrary under some law. And if the law Parliament goes ahead and fixes that law and says any such declaration of that law has to be for 5 years, that is actually not tampering with the Constitution. It is providing that any declaration in 62(1)(f) is arising out of a law, not of the Constitution. Because court of law ne karni hai na disqualification. That disqualification is arising out of a law, and the Parliament goes ahead and says any disqualification under the law has to be for 5 years. So then, with that 5 years amendment brought in, isn't the period being provided for 62(1)(f)? Because the Constitution itself doesn't give an unlimited period. It is relying on a declaration coming out of a law. And law has been corrected and given a period. So there's a distinction. Had there been a constitutional provision, disqualification like age being 25, then perhaps, to my mind, legislation could not do it through ordinary legislation. Constitutional amendment was required. But in this case, the declaration emanates from the law itself. So law is being given a certain time frame. Is pe kuch roshni dal?
My lord, it depends on